Intro as to who you are.
Okay.
We're all set.
Okay. I hope everyone is doing well today. Just as an FYI, before we get started, this call is being recorded. My name is Angela Clark. My pronouns are she, her, and hers, and I serve as the Chief Diversity, Equity, and Inclusion Officer for the Attorney General's Office of Massachusetts. I'll be moderating today's discussion featuring an esteemed panel of attorneys general who are championing diversity, equity, inclusion, and accessibility efforts in their respective states. This morning, we're joined by Attorney General Campbell of Massachusetts, Attorney General Raoul of Illinois, Attorney General Ford of Nevada, and Attorney General Bonta of California, who will be joining us a little late. Earlier this year, several attorneys general, including everyone on this panel, released 2 diversity, equity, inclusion, and accessibility guidance documents in response to recent executive orders. One on February 13th, denouncing that DEIA efforts in organizations is illegal, and another on March 5th, offering guidance for K-12 schools and higher education institutions. As a continuation of these efforts, today, our leaders will discuss the viability and legality of diversity, equity, inclusion, and accessibility initiatives across both sectors and beyond. They'll address key issues related to recent federal executive orders and their impact on diversity, equity, inclusion, and accessibility efforts. And finally, they'll share insights into how each of their offices is working to protect and advance DEIA initiatives nationwide. In just a moment, we'll begin with introductions, then move into our discussion, where each panelist will respond to questions many of you have submitted in advance. Before the session concludes, my colleague Lily will post a DEIA resource guide that includes a lot of the information that is being discussed today. In order to access this resource guide, it will require a cell phone to scan the QR codes. I will remind you throughout the discussion to stay online to access the resources at the end of the session. One last point. Before I turn it over to Attorney General Campbell to start a discussion, I would like to remind you that there is an option to turn on closed captioning by clicking on the CC or closed caption button in the toolbar at the bottom of your screen. And with that said, it is my pleasure to turn things over to Attorney General Campbell of Massachusetts for opening remarks.
Thank you, Angela. And of course, thank you to my incredible colleagues for their leadership. I am delighted and honored to be joined by my AGs from Nevada, AG Ford, AG Raoul from Illinois, and AG Bonta from California, who will be with us shortly. Apologize also for the delay in getting started. Tech issues, what can I say? But I am grateful not only to the leadership of you, Angela, and my colleagues, but for everyone who has chosen to be a part of this conversation today. Thank you for being with us. Thank you for your own leadership and what you're doing in your respective institutions. We never take that for granted. We frequently say we cannot do this work by ourselves. Yes, we know as AGs we are on the front lines and will operate with a sense of courage and a sense of urgency, but we need all of you to be in this fight with us. So thank you for joining the webinar this morning. I also want to extend gratitude to my colleagues, team members as well. None of us does this work by ourselves, so thank you to your staff for helping us coordinate this webinar. I am delighted not only that we will be talking about everything related to the guidance we've put out and explaining the details of that. But one of the things that I think is really important and worth stressing at the beginning, and we'll stress this at the end, that diversity, equity, inclusion, and accessibility practices and principles are still legal and they are still valid. The president does not and cannot change that through an executive order or so-called guidance. Since well before the election, I am proud that our offices were already preparing for this moment. We knew that we would have to step up. We anticipated and prepared for the potential threats Massachusetts might face under this administration. We expected one of those threats would be the federal government stepping away from its core responsibilities. And those responsibilities included protecting our civil rights, preventing bias and harassment in the workplace and other places as well. And unfortunately, the Trump administration has met these expectations and begun to attack the very institutions upon which Massachusetts relies and depends. The federal government, by targeting universities, hospitals, schools, nonprofits, businesses is targeting the very core upon which Massachusetts is based. These organizations are critical, and they're facing unprecedented and inappropriate pressure and threats designed to force you to eliminate DEI policies and practices. Despite these threats, I am proud that not only Massachusetts businesses, nonprofits, universities, and other institutions continue to promote their policies that are exclusive and equitable. I'm also proud that we're doing this in collaboration with other states. It is, of course, true that quotas are unlawful, and we know this. They're trying to create, or I should say, they're trying to suggest that quotas or set-asides, which are unlawful, are the same thing as our DEIA policies and practices. They are not. DEIA policies are not the same as illegal hiring, promotion, or admission preferences based on race or other practices or other protected characteristics, I should say. In fact, when properly implemented, we know, and we don't need another report on this, that DEIA policies and practices make our schools, our nonprofits, our businesses stronger, more competitive, and more innovative. They create a workforce that is prepared to meet the challenges of the day and significant opportunities to create a multicultural and multiracial democracy, not only in our world and society, but also within your institutions. Organizations in schools that invest in DEIA aren't just strengthening themselves, they're doing it together with us to create a stronger, more competitive economy and a workforce in our state that is also diverse. Fostering diversity isn't just the right thing to do. It ensures excellence. It maximizes profits. It prevents discrimination and harassment, and it absolutely decreases legal risk. So I am delighted to be on with my colleagues. I don't want to talk at you the entire time, but I know if we stick together in this moment in time when we are headed to a very dangerous direction in this country, if we stick together and operate with a sense of urgency, a moral compass, integrity, and as a collective, we absolutely can win the day. We can overcome one man, one administration, as our ancestors did before us, to really make a difference, not just for this generation, but the generations to come. So I'm proud to work with colleagues who understand the significance of not only talking the talk, but taking action to protect DEIA policies and practices, and of course, our very Constitution and the rule of law in this moment in time. They may attempt to pick off one institution at a time or one individual at a time, but they can't pick off all of us if we come together in this moment in time to do what's right, and most importantly, to do it with a sense of urgency. So thank you all for joining us. Angela, I'm going to turn it back over to you.
Thank you. Attorney General Raoul.
Good morning, and I'd like to thank my friend and colleague, Attorney General Campbell, for convening us and for all of the work that she's led on this topic and many others. It is always good to get together with my colleagues, Attorney General Ford and Attorney General Bonta. On this particular issue, this is an issue that I spent decades working towards. The idea of our country being one of inclusion goes back to the inception of our country, although there were challenges at the outset. The notion of a melting pot was concurrent with the beginning of our country, the idea that people from all over the world would come together and make one good country. There's an effort to abandon that theme of inclusion, and we need to fight back against it. Your efforts to make your schools and workplaces and organizations more inclusive and welcoming to everyone have a positive impact on the lives that you touch, but more importantly, positive impact on your institutions and your organizations. As A.G. Campbell pointed out, research shows that these efforts make your businesses and schools and organizations better environments for learning, more profitable, and more successful. Opponents of diversity, equity, inclusion, and accessibility initiatives are trying to expand the very narrow decision in the United States Supreme Court's Students for Fair Admissions decision beyond its narrow scope. The current administration is issuing executive orders, sending threatening letters, launching legal challenges against such initiatives. Ideologically driven groups are trying to strong-arm businesses and educational organizations through unfounded lawsuits and threats of litigation. For those of us who recognize the value of diversity, equity, and inclusion and accessibility, it is important to understand that what SFFA does and what it does not do. While educational institutions, businesses, and government entities may need to re-examine certain race-based programs, diversity, equity, inclusion, and accessibility efforts remain beneficial, constitutional, and legal overall. In fact, DEIA programs can help ensure that companies and educational institutions remain in compliance with state and federal civil rights laws. As we review and adjust programs where it may be necessary, it is critical to acknowledge that the impetus for such efforts has not disappeared. The effects of centuries of discrimination, disparate conditions, inequitable levels of opportunity are undeniable. They are undeniable in the past, and they're undeniable now. Our commitment to seeking equity must be equally undeniable. Do not accept the argument that the words diversity, equity, and inclusion, or the acronym of DEI, are somehow negative labels to shy away from. It is important to fight back, push back against the racist and sexist motives that would lead some people to tag people as DEI hires, to blame natural disasters or terrorist acts on DEI hires. Push back against efforts that will deny equal access to education or public spaces due to someone's physical ability. I encourage you all to maintain your commitments to your inclusive and diverse work in the school environments. Do not capitulate. It's important for your institutions and for the people who you serve. Thank you.
Thank you. Attorney General Ford.
Thank you so very much, Ms. Clark. Great to see you again. And to my colleagues, General Campbell, Raoul, and Bonta, it's always great to be able to be on the screen with them and certainly talk about something as important as this topic. It is something that is near and dear to me as well. A.G. Campbell has already talked about and mentioned already what the empirical research says. The qualitative and the quantitative research also indicates that these policies are policies that work. And I'm one to stand up and offer an recognized as affirmative action. And I've always been one to say that if it weren't for affirmative action, the scholarship that I received to attend Texas A&M University, I would not be here today. You see, I was admitted into Texas A&M University, and I was grateful to be admitted, but could not afford to go to school. And a week or so after I was admitted, I recall receiving a letter saying that I was receiving the President's Achievement Award Scholarship, a scholarship designated specifically for Black and Brown kids from disadvantaged neighborhoods who would not otherwise be able to attend the university. And graciously, they extended that to me at a time when Texas A&M was, certainly more dedicated in that day to diversity, equity, and inclusion, and ensuring that they instituted affirmative actions to increase the population of minority students at their institution. If it weren't for that scholarship, I would not have been able to not only matriculate into Texas A&M, but I would not have graduated from Texas A&M. And not only would I have not graduated from Texas A&M, I would not have gone on to receive, and this is not a bragging point, but it is a point of actuality. I would not have gone on to receive not 2 degrees, 3 degrees, 4, but 5 degrees, including 2 master's degrees, my law degree, and my PhD. And I say that again, not to brag, but to talk about the fact that affirmative action programs that are focused on diversity, equity, inclusion, and accessibility, empirically demonstrate that our society is better. Qualitatively and quantitatively indicate that businesses operate better. And anecdotally, has given me the opportunity to be here today, and not only me in this generation, but my sons, as a result of having a father being able to matriculate and graduate, now have likewise an opportunity to experience comparable opportunities in their careers. I won't tarry long, and in fact can't tarry long. I must apologize before I even finish my opening statement. I'm going to have to leave a little early. My legislature is in session here in Nevada, and I have a bill hearing actually going on right now. And I'm going to be having to exit soon after the first question or so. But before I exit, I want to reiterate something that all of my colleagues have heard me say before. Soon after the SFFA case came out, Democratic Attorneys General convened a conference. I believe it was in Philadelphia. It may have been in Boston. I can't quite remember. But we had a panel discussion where we invited entities, corporations to sit on the panel with me and other attorneys general to talk about the continued importance of diversity, equity, and inclusion. We understood, and in retrospect, I understand that there was a little trepidation there. But I will draw the simple comparison, the observation that I was able to make on that day, and I will share with you today, which is it was difficult to find someone to sit on the panel with us from corporate America to talk about the continued importance of diversity, equity, and inclusion. Again, I understand the trepidation around that. But that was in stark contrast to what we experienced soon after the George Floyd debacle and the murder. There was not a room large enough, not enough tables or seats to fit around them to hold the number of individuals who ran to discuss the importance of diversity, of equity, of inclusion, and accessibility. There literally was not enough room to entertain the conversation around those who wanted to buttress these opportunities. And I recall being asked after the George Floyd murder, as an African-American male, talking about my experience, what can we do as allies? Some would ask me, what can we do as allies in this time? And frankly, I was in my own trauma at the time and could not speak as acutely to it as I like to. But in retrospect, I wish I would have thought about this, because here's the answer. Be there when the fervor dies down. Because in fact, the fervor will die down. And people will retreat from the urgency of the moment, and they will begin to do other things. And what we have seen is that in fact, people have retreated from this notion of diversity being important, of equity being important, of inclusion being important, of accessibility being important, and of taking actions that are affirmatively desiring to improve those opportunities for everybody in this United States of America. And so my effort in having these conversations is to, as my colleagues have already indicated, remind folks that the law remains, that diversity, equity, inclusion, and accessibility programs are in fact lawful. The SFFA case was indeed a narrow ruling that has no applicability to the ability of businesses and nonprofits to be able to run DEIA programs. And that we as attorneys general will continue to stand up against those who are against diversity, those who are against equity, those who are against inclusion, and to stand with you when you want to work in these particular arenas. So thank you so very much for convening us, General Campbell, General Raoul, great to be on the screen with you, and looking forward to at least one question I may get to answer before I have to run. So thank you so much, and Ms. Clark, back to you.
Thank you. Attorney General Ford, just given the time, I'm going to come back to you to start our second question.
Yes, ma'am.
In light of these recent executive orders, many of us have started to better understand what they are and the influences that they carry. However, their implications have become increasingly complex. Can you just explain what an executive order is and how it interacts with both state and federal laws?
It's a great question, and it's one where I've had to answer several times, both to family members and to friends and to neighbors, and frankly, even some lawyers who don't work in this area as much as we do. And so, look, in simple terms, executive orders are like special rules or directives made by the President of the United States that have the power of law in some circumstances. An executive order can be used to tell the federal government what to do and how to do it without congressional approval if the order itself involves some issues specific to the executive branch, which is why the Trump administration is pushing so many executive orders, because he knows in these instances that these rules of his, frankly, would never pass in Congress. Not only that, trying to govern through executive orders sometimes is, well, many times is ineffective because they can be canceled or changed by a new president, as we have seen the last few presidents come in and change and cancel the executive orders of the previous administration. And even though these executive orders have the power of law, they're not specifically cemented into the Constitution, which means that they have limitations. On the federal level, executive orders cannot override laws that are passed by Congress, which is the reason why my three colleagues on the screen, or the three who will be on the screen, and others have already sued because these executive orders are indeed a stretch of an extension of presidential authority. The president can only direct how federal agencies implement existing laws and to fill in details where Congress has given the president authority to. And if executive order actually contradicts a federal law, the law is going to win, which again has been demonstrated by the fact that my colleagues and I have sued over the violations of these of law that these executive orders have manifested. For example, if Congress passed a law that requires specific environmental standards, the president can't use an executive order to ignore those standards. And so, I'll close by talking about interaction with the states, which is when it comes to the states, we're not required to follow executive orders that go beyond federal authority. For example, if an executive order tried to dictate how states run their local schools, you would see states challenge that as an overstep of federal power at some level. And the core of most of our multi-state lawsuits, as I've indicated, against the Trump administration is pushing back against these executive orders that are unconstitutional and go beyond the scope of the executive authority. And we will continue to stand up for the rule of law against unconstitutional executive orders.
Thank you, sir. Attorney General Campbell, Attorney General Raoul, did you want to add anything? Perfect. Attorney General Ford, I know you have to drop off. Feel free to stay, but I know you have somewhere else to be. I appreciate your time.
Thank y'all so much. Have a great meeting, everybody, and I look forward to connecting with you later on. Bye-bye.
Attorney General Campbell, can you shed some light on how organizations, particularly nonprofits, businesses, and educational institutions receiving federal funding, sustain and continue to promote diversity, equity, inclusion, and accessibility efforts in light of these recent executive orders? And I know AG Ford touched on it a little bit, would love you to elaborate.
Absolutely, and I want to thank AG Ford. We all have conflicts, and passing our bills or getting our budgets is equally important as we fight the fight. So I want to thank him and his team. Before I even get to that question, and just as a way not to have you go back, Angela, to the other question, which I think is also important, I like to think that everyone on this Zoom has a deep sense of what DEIA actually is and what it means. And before I talk about just how it may show up in different industries, I do think it's important to sort of pull that apart a little bit. What we're talking about, and as every colleague has mentioned, are not only lawful policies that are still lawful as we sit on this webinar, and no executive order, even after AG Ford has explained what an executive order is, has the power to undo the lawfulness of these policies and practices. But what does it actually mean? Because we're not just fighting the fight because we know they're lawful. We're fighting the fight because we know that it connects to the very institution and the organization's mission. Everyone on this Zoom has a mission, has a purpose. And we know that if you are promoting DEIA, it connects to your mission. And what is that? DEIA policies simply mean that we are about, all of us, even in our AGO offices, ensuring that every person, regardless of their gender identity, their race, their sexual orientation, their socioeconomic status, their lived experience, or any other identity, has equitable access to opportunity, that they can fully participate in their workplaces, for example, in their communities without fear or discrimination or harassment based on that identity. And these policies and these practices, if well-resourced, if there's enough human capital also attached, benefit not just the folks within protected groups with certain identities, they benefit everyone within that workplace, for example, within that community. They are designed and have done well to create environments that are inclusive. And so I'd like to think, and I think my colleagues would agree, that these policies and practices that we're talking about as defined in terms of opportunity align with the mission of every nonprofit, every organization, every healthcare industry, every school district in terms of what they also are looking to create. And what does this actually mean? DEIA may look different in different industries and different spaces. In the workplace context, it may mean that this is a group of folks looking to create inclusive hiring practices, equitable promotions and pathways for promotion for everyone, accessible work environments. In the justice system, it can mean expanding language access, which still remains a major issue. In our office, we're also looking at not just language access, but unbiased prosecutions. In the healthcare context, it means focusing on closing the disparities that still exist in that context. In schools, for example, it means in that sector or in that industry, making sure that our youth, even those in our LGBTQ plus community, our immigrant youth, our BIPOC youth, feel not only included, but that they don't face heightened hostility or uncertainty because of their identity or who they are. And that it truly is an environment free of harassment and bullying. Right now, as we're talking about these practices and policies and defining them, and also the fact that they may show up differently and attached to different goals depending on the industry, we're not only pushing and begging maybe even these industries to step up, but to do so knowing that we have your back, that the laws are still lawful, that everything that has existed even before this administration, particularly at the federal level for decades, has recognized that DEIA policies and practices are lawful and that they remain lawful. And what the Trump administration is attempting to do is to scare organizations by falsely equating these valid, lawful policies with unlawful discriminatory preferences in hiring or promotion, for example. And we're here to say that they are not the same. And so what does this mean? What does this mean right now in terms of organizations sustaining and promoting? One, exercising courage, and yes, courage and conviction in this moment in time, using our guidance as a tool to help you do that, knowing we have your back, and where appropriate, we will also file lawsuits as we already have in certain contexts, in the education context, you name it, in the federal funding context, to protect access to funding, to promote and protect the policies in our school districts that promote DEI. We will do our part. But we also need organizations to look at their policies, their practices, to ensure that they're not only just written in a handbook, that they're actually implemented and advanced in practice. And what we're seeing at times, not every organization, is that some organizations are succumbing to fear. And we're holding this webinar to say, don't do that. There is a real opportunity, even in the face of this very hard time, for us to come together, not only with guidance in hand, or your policies and practices in hand, but to stand together to ensure that we actually are promoting these policies and practices, and of course, providing whatever legal support that we can. I know I was sort of taking two questions on at once, but I thought it was really important to name and define what DEIA is, particularly in certain contexts. And of course, to complement what AG Ford said in terms of executive orders, not wiping out the lawfulness of these policies and practices, and also ensuring that institutions know right now they're playing a fear-based game, but our guidance, our legal actions, we want it to complement your actions, but we need your actions to complement ours as well.
Thank you, Attorney General Campbell. Just as a reminder before the next question, if you're wondering where we got these questions from, all of you had the opportunity to submit questions for this webinar in advance. And so we took all of those questions and bucketed them into themes, and this is what we received. So just want to thank you again for your participation in advance. All right, This next question is for Attorney General Raoul. Can you talk about how organizations can continue to emphasize inclusion and commit to practices like professional development, recruitment and mentoring programs focused on experiences of specific groups, even in this time?
Yeah, sure. The first is I want to reiterate what my colleague just said, is not to succumb to fear. That's critically important. And I say this with an understanding that it is difficult to face the gun of a threat of withdrawing funding or being met with a lawsuit or a boycott. But it's also important to know that if you capitulate to an unfounded criticism of your policies, this is an administration that won't stop at its first request. It will keep on coming at you because you've demonstrated vulnerability to unfounded threats. And so it's important not only to individual organizations and institutions to fight back, but it's important to us as a collective, as a country, to be able to fight back. Now, understanding that there are these threats and that there has been a sort of evolution in the legal landscape as far as it goes to redressing discrimination of the past or present, it is understandable that organizations would do an evaluation of their policies to make sure that they're consistent with the law. I don't frown upon that. And in fact, I think we collectively encourage that. That does not mean backing away from the nomenclature of diversity, equity, inclusion, or accessibility. We cannot succumb and should not succumb to this notion that DEIA or DEI is suddenly a bad word or something to be tagged on to one's definition as a DEI hire. It's important to double down on the type of policies that prevent discrimination in the workplace or at an educational institution in the first place, and not to back away from those. And so those are often elements of DEI policy. And so it's important to continue in the workplace, embracing employee resource groups, to review statistics, to see how inclusive the environment actually is, to embrace pipeline programs for students and for employees. None of that is illegal. And to the extent that we don't back down to the threats of the administration or ideologically driven groups, we preserve those as tools of making our institutions, organizations, and workplaces as successful as they can be. And so I would say, fight back. You can do the evaluation, continue to do and to embrace the tools that create a diverse and inclusive workplace.
Thank you. Attorney General Bonta, welcome to the call. How are you?
Hi, everybody. Good to see you. Thank you for understanding. I had carpool this morning, so I just dropped off my son, got a little off track today. So a humbling start to a Monday, and very excited to be with you. Thanks for having me.
Thank you. Just wanted to allow you to speak really quickly, just quick introductions, and maybe talk just a little bit about some of the work that you and your office are doing to support DEIA efforts.
Yeah, thank you. Such an important conversation. I'm glad to be part of it today. I can't echo enough and reaffirm and emphasize enough AG Raoul's points about standing on your rights, pushing back. DEI is completely lawful. Diversity, equity, and inclusion programs that tackle discrimination, that push back against harassment. It is completely irrational and mind-boggling to suggest that the things that address discrimination are somehow discrimination. and our core constitutional provisions and laws in the United States, like the 13th, 14th, and 15th Amendments, the Civil Rights Act of 1964, the Voting Rights Act of 1965, the Americans with Disabilities Act, the laws that tackle age discrimination and promote pay equity, those are all what folks would call DEI. And they're good for society, they're good for business, they're good for education. When more people have access to business and education, we have more talent in the pool, and when we're removing barriers and including more folks. So it is completely lawful. I honestly don't even think that the president and the administration know what they're talking about when they say DEI. We don't know what they're talking about. It's vague, it's ambiguous, it's a culture war, it's a three-letter term, like critical race studies and ESD and everything else. People will tell you that they think it's bad, but they don't know what it is. And so we know what the law provides for, and we know what tackling discrimination means and tackling harassment and how important it is. And so this is a time to have courage, to fight back, to stand on your rights, to make sure that the progress we've made as a country and as a society is preserved and is continued. And the bullying that is unlawful through these executive orders that cannot change our Constitution or change anti-discrimination laws are not something that we should accede to, capitulate to, or acquiesce to. So I encourage everyone on this call to continue to stand up for your rights. And that means continuing to promote lawful diversity, equity, and inclusion programs.
Thank you, Attorney General Bonta. I know we talked a little bit about Students for Fair Admissions, aka SFFA, Attorney General Campbell, and then Attorney General Bonta. What does the evolving landscape mean for schools in terms of just diversity, equity, and inclusion programming?
Thank you, Angela and AT Bonta. Totally understand. Good to see you. And we, of course, value your collaboration and partnership. I think it all echoes what we've been saying is the SFFA case was a Supreme Court case only dealt with higher ed, not even K through 12 system, higher ed. And it was about admissions practices in higher ed education. The Supreme Court said and made it clear and decided that the federal law that prohibits colleges and universities from using race as a plus factor in admission decisions, that, in other words, you can't do that. You cannot provide race-based preferences to individual students. That case has nothing to do with the employment context. That case has nothing to do with the K through 12 context. And we've made that crystal clear throughout this conversation. It is very limited to higher ed in this very limited admissions case. And for folks who have more questions on that, we've all put out guidance on that even before the Trump administration. So I would encourage all of you to look at all of our resources on all of our AG web pages as to what that case means and what it doesn't. Fast forward, why we as a collective are not only putting out guidance that DEIA policies, even in the face of that decision, are lawful, and that an executive order cannot wipe them out, is because we know people need more information. But we also know that information is not enough. Just like we're asking all of these institutions that have joined us today to take some action, which is not to succumb to fear and to implement your DEIA policies and to beef them up. And frankly, I would say be more aggressive, because in this moment in time, we need these policies more than ever before. We also, as AGs, are taking action. So we have sued the administration for threatening to withhold funding from public schools, for example, that incorporate and continue to incorporate DEI programming in their curriculum. We have a number of lawsuits defending and pushing for federal funding that has been cut because it's seen as furthering DEI. So we're taking a whole bunch of actions as AGs against this administration and making it clear that the Supreme Court in the SFFA case that they're relying on is not only is it not appropriate, it's not relevant to their arguments, and it's also not accurate. It's misinformation. And so in these lawsuits where we're fighting to protect access to federal funding because they're trying to condition that on DEIA or other policies, we also, in addition to our action, are supporting others. We're providing legal support in indirect ways through our amicus filings to private businesses, to trade groups, associations, higher ed institutions, you name it, those that are also standing up for their rights. And so as you're thinking about how you also come and push through that fear, know that we're willing to also take action as well to protect organizations and institutions and lawful action that will complement them standing up as well. And then lastly, because I don't want to take over the whole conversation, this Dear Colleague letter is also significant. And we stood up and fought and filed against that, putting out guidance, legal guidance in our respective states to make it crystal clear that this Dear Colleague letter was not only unlawful, it was inaccurate and misinformation. And that we will continue to promote higher ed DEIA policies in higher ed contexts and other industries as we've described. We will also make sure that our K through 12 systems know that they can continue to pursue DEIA policies, and they should. They're lawful. The Supreme Court case, SFFA has nothing to do with K through 12 schools. And if anything, in this moment in time, we know that schools and employment contexts, really important that you really push these policies, because if you don't, we're going to see probably an uptick in discrimination claims or environments that are not as inclusive as they need to be, given what our young people are facing in this moment in time coming from the federal administration. And I'll now turn it over to AG Bonta or even AG Raoul to add.
Yeah, I'll just emphasize the key points around the narrowness of the Students for Fair Admissions case. It applies where it applies, but it doesn't apply outside of that context. It's a higher ed case. It doesn't apply to other parts of the education system or certainly in the business world, although there is a attempt to weaponize it to apply everywhere on everything by the right. They're sending letters that are intimidating, Republican AGs telling businesses that they need to end their diversity, equity, and inclusion programs and citing the case. But the site doesn't support their position. And this is something that I've described as a soft power that they have. The legal authority that they point to doesn't justify their position, but through intimidation, fear, scare tactics, they are bullying folks into submission. And even though the action that they are asking is not required based on the authority that they're citing. So as an attorney, and as you have attorneys in your office, look for the guidance. And there's clear requirements that the Supreme Court case requires, and we will follow Supreme Court cases. We follow court cases and comply with court orders. But the case is narrow, and so it should be read as such. And you know, I know that there's folks who are worried about losing funding, worried about getting into conflict with the federal administration, and attorneys can be risk averse and I'm sure there's advice and counsel to avoid conflict. But this is a time to stand up for our rights and not be bullied into conceding on things that are not required by the law. The law is our North Star. The law is our guide. We follow the law, and including the aspects of the law that allow us to, and sometimes require us, to take steps to create more inclusive environments that don't discriminate and that provide opportunity for all of our communities. So read the case for what it is, not for something that it's not, and please push back on these bullying efforts that try to require you to do something you're not required to do.
Thank you. Attorney General Raoul, this next question is for you. I'm hoping you can start this question. And again, all of you have touched on this a little bit throughout your comments, but what specific actions can organizations take in response to the threats of investigations and litigations by the federal government?
Well, obviously, it's always a positive thing to consult with your counsel. However, as AG Bonta just pointed out, it's important to not just surrender to this notion of just being risk averse in your balancing of what is worthy of fighting for. As I indicated earlier on, we're dealing with an administration that's not going to stop at the first threat, particularly if that threat shows some level of success by being able to achieve some level of capitulation by a target, even when there's no sound reason for the threat in the first place. And so I think it's critically important, while doing that initial evaluation of existing programming, to act on the affirmative, to preserve the spirit of diversity, equity, inclusion in programming. And so what that means is, again, in the context of even college admissions, it's important to know where, even in that narrow context, what SFFA prohibits and what it does not prohibit. It does not prohibit seeking ways out to expand the pool of applications that may come into higher education institution. It does not prohibit creating a welcoming environment within institutions for diverse groups based on their backgrounds. It does not prohibit. In fact, there's dicta from Chief Justice Roberts that indicates that applicants can, in fact, talk about how their race has impacted their lives and how that can be taken into consideration. So even in the context of higher education, it's important to note what SFFA still allows in the admissions process. And if it allows that in an admissions process, certainly consistent programs and tools are allowable in the business, in the workplace, as well as in other organizations that are being threatened. Our Republican colleagues have misused the SFFA v. Harvard decision to threaten corporate CEOs as well as others. And it's important, my state is in the midst of litigation on multiple cases, and we are fighting back. And before I ask any other organization to do something, I do it with mine. And so here at the Illinois Attorney General's office, we have employee resource groups. We make sure that we go to affinity bar associations and affinity law student associations to recruit future assistant attorneys general. We look at our data. We review our data to see how we're progressing on making certain that what I fight for to exist in other institutions, I make sure I point the finger at myself first and make sure that I'm doing something affirmatively to do it within my own organization.
Thank you. And I think you started to answer the last question. So now I'm going to turn it over to Attorney General Bonta and then Attorney General Campbell to close us out with what Attorney General Raoul just started. The last question, and I'll start with, again, Attorney General Bonta. What specific actions are you taking to protect and preserve the legal DEI measures in your office?
Well, we are unapologetically continuing with our lawful diversity, equity, and inclusion programs in our office. We have a specific DEI lead role. We have that she oversees a whole number of programs in our office. We think it's important to embrace our diversity and create an inclusive environment, and that makes us more successful, and that makes us a better office. And when all talent is being put into our collective efforts, we're stronger and better, and we can serve our constituents better. And so we are continuing with our DEI programming, and we want other folks to as well. We are bringing lawsuits as attorneys general, as we've discussed, when we have standing, when our states have been harmed, whether it be the Title VI requirements redefined by the administration in a way that's completely unlawful. We, of course, will always comply with Title VI and have committed to that, but not there redefined, transformed definition of what Title VI means as they wage their culture wars. And when we don't have standing, I think our team of AGs is very eager to participate as amicus when others stand up. And for those who are targeted, I think there's strength in numbers. When if a business sector is being targeted, or a sector of the education world, you can join together, you can hire counsel, you can go to court, you can seek a restraining order. I encourage that. If your evaluation is that your laws, your rights are being violated, and that the action against you is unlawful and should be stopped, I encourage you to stop it in court. And we would be eager to help through amicus and through the work that we're doing. We can't sue on what we don't have standing for, but we can participate in other ways. And I think it's important for everyone to stand up and push back. We saw the opposite with some of our friends at law firms. Some courageously stood up, fought back, are getting restraining orders in court for these executive orders that are unlawful, that are attacking and targeting them. Some did not, and perhaps they wish they did, because if they fought, they would have won. And it's important to fight back. But we lead by example. I'll just end where I began. Our DEI programs in our office, our diversity, equity, inclusion, staff, resources, programming, services are as strong as ever and only growing, and we are doubling down on them, not going back.
Attorney General Campbell.
Yeah, I'll say a few words, and I know we started late, so we're going a little over, but I'm actually going to end with AG Raoul, because I do want him an opportunity to sort of close out as well with any final thoughts. And I want to thank everyone for joining us, because I think it's important to recognize as we do this work, all of you are doing this work, and it is hard work. And the majority of folks who actually do DEIA work are Black folks, or people of color, or women, or Black women. So it's a tough job right now, and I want you to all know that we recognize that, hence why we continue to show up on this issue. Others may not prioritize it, but we are. And we are showing up not just with guidance, but also filing lawsuits where we can, supporting private entities where we can, who are also filing lawsuits. We're taking action. We're putting up a mirror to our own institutions and asking ourselves, do we have a DEI chief? Angela, thank you. Do we have an office that is resourced doing this work? Are we doing everything in our own power, within our own organizations and institutions, to promote DEIA policies and to do it effectively and impactfully and with a sense of urgency? And I'm proud that in Massachusetts, we can say yes. We're looking at not only the numbers in terms of who we employ, but the diversity of who we employ. We're looking at our vendors to the extent we have resources to give out externally. Who are our vendors and what does our supplier program look like? So there's a whole host of ways for our organizations to step up. And I'm proud to work with AGs that are putting up that mirror at the same time that we're asking folks to be courageous. Two other points that I think it's important to make. Each of our states has laws on the books that require affirmatively that institutions not discriminate, that they promote the civil rights of everyone, that they promote safe and welcoming environments, especially in the context of our K-12 or school systems. And none of us want to use our laws to go after the very folks that this federal administration is targeting and threatening and attacking. We want to work in collaboration because we understand their strategy of fear-mongering and divide and conquer and divisiveness. We want to work against that. So we're here reminding folks what our laws are in our respective states, because they are still very important. And we want to implement them by working in collaboration with you. We don't want to employ a strategy that the federal government is employing to try to get you to follow the law. We're saying we're here to support you in not only the work we're doing and giving you information, but to remind you that we have laws in our respective states that require us to show up for our people and, of course, to advance their civil rights. And I would say for those lawyers or others that are risk adverse, as AG Bonta said, we've seen it, rely on your state laws. They have not gone away. They are not lesser than an executive order in this context. If anything, they are lawful, and they require us to comply with them. And then I'll end with this. I'm not just an AG. All of us on this Zoom, all of us AGs, we're parents. We care about our children, and we care about what happens to them in the next generation to come. And we know that in this moment in time, as dark and divisive as the time is, our children are struggling. And this is a real opportunity for us to look ourselves in the mirror and ask ourselves what we're going to do in the face of what we're seeing in this country, particularly the attacks on our young people, the attacks on our school districts, and to use that as a way in which to advance the work in spite of the fear that may exist. All of us are in this work to ensure that the next generation not only has a society, but they have a constitution, they have a rule of law that matters for the promotion and advancement of their rights and also our economy. And they have DEIA policies that not only value their identity and who they are, but most importantly, create environments and opportunity for them to get a fair shot in this country. That's the work we're doing, and we need your support in that. And we need folks to, in the midst of all of the fear and the fear mongering, to ask themselves what they're going to do in this moment in time to join our efforts. We know we are limited in what we can do, hence this webinar and other ways in which to push you past your fear. And we'll continue to do that, supporting every step of the way. And most importantly, not forgetting that we really do this work for the kids and the next generation to come. So thank you, Angela. I'm going to turn it over to AG Raoul to close us out before you put resources on the screen. So thank you to my colleagues.
Thank you, AG Campbell, and thank you again for convening us, and thank you for your leadership and yours, AG Bonta. I really enjoy working with my colleagues, and particularly on this issue. I know for many of you all, you have access to counsel, and you may or may not look at the guidance that we have put out, or you may or may not follow the guidance that we have put out. And we're not here to mandate you to do one thing or the other, but we are here to ask you to look in the mirror and to recognize the time and recognize what's going on here, the racism behind it, the effort to divide our country and to make it less inclusive. And at a time like that, it is important to not just seek out the easiest way out. I know it could be easily to just review your materials and strike from them the words diversity, equity, and inclusion, and say to us in response when we may call on you, oh, that we still have the same commitment, we just took the language out. But that's capitulating, just to say. There's nothing inherently wrong with the nomenclature of diversity, equity, inclusion, or accessibility. And we should not run from the language because we have an administration and extremists that seek to have us do so. It's all in an effort to divide our country. And unless we fight back at each and every point fully and do not even surrender on the nomenclature, unless we do so, we're allowing them to be successful in dividing our country. So I end with just asking us to collaboratively fight back. We, our AG community, will be there to support you.
Wow, that was a good ending. Thank you. Okay, so I'd like to just end with, thank you all for being part of this really important conversation. We are obviously grateful for your engagement and commitment to advancing diversity, equity, and inclusion and accessibility in your organizations and your communities. Thank you to Attorney General Campbell, Attorney General Bonta, Attorney General Raoul, and Attorney General Ford for sharing all of your insights with the public today. These conversations are clearly essential as we continue to navigate the evolving landscape of DEIA and work toward more just, more inclusive, and more equitable systems so that we all thrive. We hope today's conversation offered clarity and practical guidance you can take back to your organizations. On behalf of all of us, I want to say thank you. And lastly, two things. I'm going to ask my colleague Lily to post our DEIA resource guide before you leave. I will say you need to grab your phones. You definitely need a cell phone for this piece of it. We will make sure this is sent to you post today's webinar as well. The other thing I would mention is this Friday, May 16th, the New England Attorneys General, including our very own Attorney General Andrea Campbell, are hosting a town hall to discuss how they are confronting the federal administration's damaging and unlawful actions. And they'll be taking questions from the New England community. So this will kick off on Friday at 6 p.m. at IDEW Local 103 in Boston. We will also make sure you receive that information. So with that said, we want to thank you all for your time today.
Bye, everyone. Thank you.
Thank you all.
Bye, everyone.
Thank you.